Why is the FTC appealing this? Why take these challenges that are very hard to win?
The current leadership of the FTC has decided that they want to try to move antitrust law in a different direction than the courts and the agencies have brought the law for many years. Antitrust law in the U.S. is common law. It's interpreted case by case. And they've decided that they want to go in a kind of a starkly different direction. So they keep bringing forward cases with their aggressive theories, but the courts are not finding them convincing. They're not finding them convincing on the facts sometimes, and I think in the Microsoft-Activision challenge, on the law and certainly on the economics. So I think the leadership feels that they want to try to push the boundaries, but the courts are just simply not amenable to that. The courts look at what's the precedent, what's the case law, what are the standards that are already in place.
Ultimately, they're worried that these sorts of vertical deals can ultimately end up just with companies having far too much control and indeed monopolistic sort of outcomes. Do you have any sympathy for that at all, whether or not we see the law as it stands being sympathetic to it?
If there is good evidence that a merger, whether it's a horizontal or vertical merger, may substantially lessen competition, there's a strong basis in the law to block those deals or to have remedies in those kinds of deals that preserve competition. When I was the chair, we brought some vertical merger challenges and we had settlements in those. But I do think the law certainly prohibits it. The question is, do they actually have the evidence to convince a court that the deal, whether it's a horizontal or vertical deal, will actually meet that legal standard? And the government bears the burden of persuasion. They have to persuade the court that it would substantially lessen competition, and they just haven't carried that burden.
What about Congress weighing in here more broadly? And some have been saying, look, as it stands, the way in which we interpret the law isn't right, and the way in which we see competition is outdated. Do you think that that's the case? Do you think we would ever see the ways in which we judge the legality of such deals being altered by Congress?
There has been some interest in members of Congress in changing the law, but it just hasn't gotten the support of the broad membership of Congress to do that. Look, antitrust law is not static. As economic learning, as our understanding of markets, as markets themselves change, antitrust law, the case does need to change too. And it's generally been done through case-by-case enforcement. And we've seen those developments. We've seen, when I was at the FTC, winning cases before the Supreme Court that supported our enforcement efforts. So it's not that the law, the current law is totally static. But to make this sort of big break from showing what's a substantial lessening of competition or departing from the consumer welfare standard, which is really the lodestar for antitrust, would necessitate a new law in Congress, and we just haven't seen the momentum for such a law to pass.
No, your expertise is so important to us because you were the acting head of the FTC under the Trump era, but I'm interested in your perspective overseas. What do you make of the UK and the way in which we could see further sales be forced of Microsoft and Activision in this particular instance? And ultimately, would that mean that would have to be done worldwide?
Well, it really depends. The CMAs authority is only for impacts in the UK. So that would be very sort of fact specific and market dependent. On whether some sort of remedy that was limited to the UK would address those concerns. But the CMA is kind of out on a limb at this point, right? It's the European Commission cleared the deal. The US thus far has not blocked the deal. It's been approved by regulators around the world. So I think they're in a very interesting position. And is there some sort of last minute remedy that will, assuage their concerns and allow them to approve the deal. I think is something that's I assume is under intense discussion, given the state of play.
In your current role, chairing the global antitrust and competition practice at the law firm Baker Botts, what are you advising clients in this current, environment we're currently in? Do we think that deals have got harder to be done or not?
It's kind of a twofold question. The process of getting your deal done, the approval process, is likely to be more onerous and take longer. You may have to produce more documents. You may have to, sort of engage in theories that weren't really strongly supported in the case law, but if the regulator brings them up, you have to talk about them, you have to address them. But ultimately, what we're finding is if the deal makes sense, if it's pro-competitive, our recommendation is you should go forward with it. The law itself has not changed. And that's, I think, what we're seeing in these repeated failures of particularly the FTC to win these challenges. So ultimately, for clients, that's what they need to decide. Are they willing to kind of go through a process that has been made more onerous, specifically made more onerous, I think, to try to deter some mergers, even if they can't win in court by saying they're anti-competitive. But if a merging party is willing to go through that, they have the same chance that they had in the past of winning if there is an appeal, because the courts are sticking to the case law and the the requirements that were already in place. They're not buying these new theories.